The Karen Reed detectives are either the most colossally inept, monstrously incompetent police officers on planet Earth, or they're corrupt. You get to decide. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. For the most part, I'm a law and order guy. I respect police officers who lay down put their lives on the line every day. As the fictional Joe Friday once described it, it's a glamorless, thankless job that's got to be done. It's one of the few jobs in the world where you can be walking toward a car one moment, one that you've just pulled over, and then be shot at just a few seconds later by the people you were pulling over to give a warning. And of course, you don't get a warning if you're a cop. So, in most respects, I tend to cut police officers some slack. I don't expect them to be perfect. I am usually much more amazed that some of the folks can remain professional when they are confronted with the idiocy of people who are like sovereign citizens who just refuse to bring their thought processes within the realm of logic. But generally speaking, like I said, I'm pretty much a pro police officer guy. But most of what police officers do in terms of arresting people winds up in court. And when you get into court, the way cases are decided is through evidence. And in terms of collecting and processing evidence, I believe in strict adherence to best practices in order to preserve all evidence, especially that which points toward innocence. The Brady Rule is in effect for a reason. Many times, some detectives simply don't ask the next relevant question, not because they don't want to know, but because they suspect and they're afraid that the answer might wind up hurting their case. I have numerous criticisms of the Massachusetts State Police in the Karen Reed case, and that's coming in a video in a few hours. But right now, I want to concentrate on the way things should be done. With the proviso that I am not an evidence technician, I've never been an evidence technician, I've never done the job, but I do know what I can read on the various organizations that set standards for evidence collection. Police departments, with perhaps the exception of the Massachusetts State Police, generally follow established best practices for evidence collection and storage. To ensure the integrity of evidence, preserve chain of custody, and uphold due process, they gather evidence and they process it in a manner that is consistent with proving things in court. Those best practices are guided by law, departmental policy, and national standards such as those from the International Association of Property and Evidence and the National Institute of Justice. Here is a summary of some of those best practices. First, you absolutely have to secure the crime scene. Normally, police officers do this through establishing a perimeter. They use crime scene tape or police barriers. You've seen this not only on police shows like CSI, but if you watch a few body cams here on YouTube, you'll see that one of the first things they do at a fatal crash is put out crime scene tape. And that is to rope off the area where it is most likely that evidence will be found. As I said the other day, the crime scene is not just the place where they find a body. The crime scene is the place where the elements of the crime can be committed or could have been committed. The size of the perimeter at a crime scene is determined by several practical, legal, and investigative considerations, with the primary goal of preserving evidence and protecting the integrity of the scene. Here are the main factors that influence how large the perimeter should be. First of all, there's the nature and type of crime. Violent crimes like shootings, homicides, that sort of thing, usually require large perimeters due to the possibility of scattered evidence like shell casings, footprints, or blood trails. Property crimes like burglaries may need smaller but still secure perimeters. Then there's location and terrain. Open areas like fields, parking lots, or front yards in some cases often need much wider perimeters to account for potential evidence being farther from the location of the body or the victim and the scene itself. In buildings or confined spaces, the perimeter may follow the structure's layout, like hallways, stairwells, and adjacent rooms. But for large open areas, you need a large perimeter. If evidence is visible beyond the initial area, like drag marks, broken glass, shoes, that sort of thing, tire tracks, the perimeter should expand accordingly. The absence of evidence in a clean crime scene may warrant a large perimeter to detect trace or overlooked items. Then there are entry and exit points. Perimeters should include all possible points of access and egress, such as doors, windows, gates, alleys, or paths, to identify escape routes or overlooked evidence. Safety concerns. Officer and public safety may require a larger buffer if weapons, hazardous materials, or unstable structures are involved. And then there's media and public interference. High-profile cases may need expanded perimeters to keep the media and the public at a safe distance in order to avoid contamination of the crime scene or tampering with evidence. Then there's flexibility. Perimeters often start large and wind up contracting as they assess the scene, as the investigators get out there and start looking at and documenting the evidence. It is always better to start wide and shrink than it is to start small and then have to expand it, because you don't know what happened in the area you're expanding to before you got the crime scene into that area. And that never makes you look good in court. The supervisor or lead investigator's judgment is paramount. If his investigative judgment is not good, then your crime scene is going to have problems. Final discretion usually lies with that lead investigator or commanding officer based on their experience, scene dynamics, and investigative priorities. Size is one thing, but access is another. You have to limit access to authorized personnel only, and you do that until all evidence is collected, photographed, and inventoried. In other words, you wouldn't want to leave a front yard open to the public at large for, I don't know, 3 to 14 days before you got around to collecting all of the evidence. You want to log all the entries and exits into the scene. At pretty much every murder scene where a perimeter has been secured, there is a cop standing by the one entrance to that crime scene, and he's there to log people in and out and note what was taken in and what was taken out, and ensure that everybody who comes into that crime scene wears a shoe booty on their shoes. And if they have a lot of hair, that kind of thing, that they wear hair nets and beard nets to protect the physical scene, which may be collected by the evidence technicians and lead to false evidence, obviously. And then you want to avoid disturbing or releasing the scene until documentation and collection are complete. Like I said, you don't want to leave the darn thing open for 14 days to let anybody who wants to wander through there. These things are done so you can assure a jury that nothing was added to or taken away from the crime scene, thereby giving a guilty person a pass. And then there's the business of actually collecting the evidence once you have secured the crime scene. You have to use appropriate tools and personal protective equipment. You want to wear gloves and you want to use forceps and masks to avoid contamination. DNA has become such a huge part of forensic investigations that attempts should be made to prevent the transfer of DNA onto surfaces. Many times, it is possible to transfer DNA by touching a part of one surface, like, for example, a couch, and then later touching something like a knife laying on the floor, and the DNA of someone who sat on the couch who has absolutely no relationship to the crime gets transferred to what may later become known as the murder weapon. You want to photograph and document the evidence in situ before moving it. So you've probably seen images similar to this one, where police have photographed bullet casings or murder weapons or other things at the crime scene. That is done to show exactly where the evidence is found. And you'll notice from the cross-examination of Sergeant Bukhenik that was not done. There were large pieces of evidence that he could not recall when they were collected or who collected them or what he did with them. That's not a good thing. That's, again, to show exactly where the evidence is found, because that may have significant impact on calculations about speed and that sort of thing, timing. There are lots of different things that go into a crime scene examination. And if you don't have evidence of where things ended up, there's no way to figure out how they got there. Then evidence has to be labeled with the case number, date, time, location, collector's name, and description. And it needs to be done at the scene. As hard as it is to believe, there are lots of crimes every day. Many of them wind up going to trial. So a cop doesn't know, as he's gathering evidence at a crime scene, whether that evidence is going to be needed to get a conviction or not, or whether the suspect might later plead guilty. But they enhance their chances of the suspect pleading guilty where they document the evidence thoroughly. One reason they do this is because they know that clients routinely lie to their lawyers. A few years back, my boss strongly encouraged me to represent a DUI client who was a friend of his wife. She had been picked up by the local police department. She swore when she came in for her interview that she wasn't drunk, that her back reading was wrong, that the blood alcohol draw would prove her innocence. So I called the prosecutor and asked if I could meet with him. He said, "Yeah, I want you to come on over. I want you to look at the dash cam footage." So after looking at the dash cam footage, I was pretty sure that no jury in their right mind would have found her not guilty. She was a kindergarten teacher, and she was swearing using words that very few kindergartners know. She was suggesting that the police officer who was detaining her performed certain anatomically impossible feats involving aerial acrobatics and rolling donuts. Every other word was slurred. I worked out a deal for her to plead guilty, and the blood alcohol draw came back at 0.31. Not exactly a rookie level of intoxication. So photo and video are very important parts of evidence gathering. When physical evidence is found, cops have to use the proper containers: paper bags for biological evidence like blood-stained clothing, plastic bags for dry, non-biological items like weapons and electronics, evidence envelopes or boxes for small items like bullets, and you have to avoid cross-contamination by changing gloves and using clean tools for each item. That prevents cross-contamination for things like DNA, which can be and often is transferred by touch. And then there's the chain of custody. Obviously, when a police officer picks up a knife at the crime scene, he doesn't keep it in his pocket until trial. He bags it and sends it to the evidence locker. So every step of the way from the collection until the police officer opens it up at trial must be documented. Usually, it's a police officer to evidence technician to DNA analyst, analyst back to the evidence technician, and then to the evidence locker. The evidence technician removes it from the locker on the day of trial and then gives it to the person who's going to be taking it to court, whether that's the DA or it's the sergeant who's going to be testifying about it. And that person signs for it and notes it on the evidence bag as well. In this manner, it is known that no one switched out a bigger, uglier knife for a weapon collected, and if the knife is tested by the defense, similar documentation must be done, because a lot of times if there's enough DNA left after an examination, a independent DNA lab may be asked to test it to make sure that the police officers got it right. In other words, you document every person who handles the evidence, you log the transfers with time, date, purpose, i.e. from crime scene to the lab, and you maintain a paper or digital trail for every movement or access. Then there's evidence storage. You use a secure access control facility. Evidence rooms with card or keypad access. The key here is when you have a vehicle in evidence, you have to control access to that vehicle. Separate storage for different types of evidence, refrigerated storage for biological samples, firearm lockers for firearms, drug vaults for things that have a high potential to get stolen, fireproof, climate-controlled environment for sensitive materials like documents and electronics, and key card storage in a garage with video for autos and motorcycles. Digital evidence is also important. When phones are collected or computers or iPads, their information must be protected. So they use a write blocker during collection to prevent modification. A write blocker will work as a one-way valve, allowing someone to look into the device, but not allowing someone to manipulate the device or overwrite information on the device while they're collecting. Hash values are used to calculate and verify the integrity of the information, and digital evidence is stored in secured access limited servers with audit logs, so you can tell who got into it, who looked at it, when they did it, and what access they had. And then at the end of a case, you have to follow the state and local law for how long evidence has to be retained. You document all the disposals, and you get court orders or written approval when releasing evidence. In addition to all that, you do regular audits and inspections to conduct spot checks or chain of custody logs and storage conditions. You want to make sure that the people who are charged with doing this evidence preservation are actually doing their job. And perhaps most importantly, training and SOPs. Officers and evidence technicians must be trained in evidence handling, and departments should maintain clear written standard operating procedures or SOPs to guide the preservation of evidence. Not only is all of this necessary to prevent a smart defense lawyer from raising an issue, it's usually necessary to lay a foundation for the admission of the evidence in court. Something like this.
Did you collect this knife at the crime scene?
No, Officer Abe did that.
What did he do with it, if you know?
He bagged it and wrote his badge number on the evidence bag.
Was there an evidence log initiated?
Yes. When Officer Abe got to the station, he handed it over to Officer Betty, who entered it into the evidence log for this case.
Can you identify this document?
Yes, that's the evidence log.
What does it establish as to the chain of custody?
It shows it was sent to the crime lab by Betty, that Cedric in the crime lab signed for it, worked on it, and he sent it to Dwayne in the DNA lab. Dwayne tested it and sent it back to Betty. Betty put it in the evidence locker and took it out this morning and handed it to me, and I brought it with me to log, and the log along with it, to the court today.
I'd like to offer this knife into evidence, Judge.
So that's basically the process of collecting evidence. And as you'll see here in a little bit when I put out my next video about Sergeant Bukhenik, that was just not done in the Karen Reed case. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.